Good evening, everyone. A warm welcome to all of you to this webinar, which is on a very important topic of establishing US residency through EB-5 program. This program is for those who either themselves or their children are planning to migrate and settle in the US. We have Mr. Piyush Gupta with us to give a detailed overview of this program. Piyush is from Canem Enterprises and is responsible for Canem's client and business relationships in India and the Middle East. He did his MBA from a university in Hong Kong and has 12 years of professional experience. We also have Anurag Madanikar, who is from Henley and Partners and has 15 years of experience. He would share his perspective about this program and briefly about the gold card introduced by Mr. Trump. We then have Lloyd Pinto, who will speak about pre-immigration planning and US tax implication. Lloyd is a partner with Grant Thornton Bharat LLP and is leading the US tax practice here. He, since 2004, has been instrumental in assisting numerous Indian companies and individuals manage their US tax and regulatory compliances from India. Myself, Nilpa Gosrani, I'm a CA with 2 decades of experience in tax consulting. I will throw some light on key India tax and regulatory considerations. So I will now request Piyush to share an overview of the EB-5 program.
Thank you, Nilpa, for the introduction. Hello, everyone. I'm Piyush Gupta. I'm based in India for Canam, and as Nilpa mentioned, I lead our efforts in India and the Middle East. I have a brief presentation today to talk about and introduce EB-5 program, the investment structure, what you as an investor should consider while making this investment, the role that Canam plays, and a track record. So what is EB-5 program? Introduced in the 1990, it is one of the oldest investment-based immigration program. Since then, it has seen several iterations, including the regional center way of investing, the most recent being the 2022 Reform and Integrity Act, which introduced further checks and balances and provided more transparency for investors. At its very basic, there's a minimum 800,000 investment that needs to be made in a targeted employment area, which should create 10 jobs in the US economy. And the $800,000 that you invest need to be documented for their source. EB-5 is a permanent resident, is what leads to permanent residency in the US. So you get added benefits of the freedom to live and work in US. It is a path to citizenship, potentially lower cost in state tuition, and freedom of travel and moving around. However, the most important benefit that Indian investors seek is the freedom to live and work anywhere and not be dependent on employer authorization for your career progression. And that's really why most of the Indian investors are parents investing for their children studying or working in the US and helping them circumvent the uncertainties and the bottlenecks that typically get associated with an H-1B visa. Increasingly, there are companies that are avoiding providing jobs and even internships to foreign students who would require a work authorization. Now, I mentioned 2022 reform. One of the key benefits that was added in the reform was the facility to do a concurrent filing. This effectively allows a student on F1 visa or somebody working on the H-1B to be in the US, change their status while waiting for their EB-5 application to get adjudicated. This brought huge relief to students and people on H-1B alike. This allowed them to not leave the country and change their status while waiting for the application to get approved or processed without completely alleviating the uncertainty of the waiting period. This is a broad EB-5 immigration process. There are a few nuances that once somebody discusses one-on-one would go through, and it's subject to some conditions. But broadly, you choose an investment, you get your source of funds documented from an immigration attorney, and then have the immigration attorney file what's called an I-526 application, which is essentially a conditional green card application. Now, if you're already in the US, you have the eligibility to file for an adjustment of status while you wait simultaneously with the I-526 application. If you are, however, not in the United States, you need to wait for the approval of your application and then go for an appointment at the respective consulate. Once you are on a conditional green card, there is a mandatory 2 years of conditional residency that's required. Soon before the completion of this conditional residency, you will file what's called an I-29 application, which is removal of conditions. This is where the regional center will provide you with the proof of job creation, or you as an investor need to provide the proof of job creation. And that's essentially the main condition at this stage. Once the jobs are created, because that is one of the primary conditions here to go to an unconditional green card, your application gets processed accordingly. This is also around the same time where the investment, typically, which is a debt-based investment, especially with Can-Am, we only do debt-based investment in EB-5, is also the loan term maturity time. So around this time, you also would likely get eligible to get repayment of your principal. So where does Can-Am come in all of this? Can-Am Enterprises is a regional center. It is, we do the project due diligence, and then we have teams around the world, and we structure the EB-5 investment, and then speak with investors who are interested in the EB-5. We've been doing this for over 2 decades, and over this period, we've raised about $3.5 billion in EB-5 capital, and more importantly, repaid $2.27 billion. Now, this is based on our recent audit. This number has changed. However, in this time, we do enjoy 100% success rate for our projects at the both I-526 as well as the I-29, which means that all our projects so far have met the guidelines at the conditional green card stage, as well as the projects that have reached that stage have been able to prove job creation for investors to move on to the unconditional green card. I mentioned that the number has changed a bit in terms of repayment. Recently, in January, we announced repayment of one of our most iconic projects in 2018, the Spiral. This was a project by Tishman Speyer, where we had Blackstone as a senior lender. Another interesting thing in this project was that majority of the investors were of Indian origin. With this 215.5 million repayment from this project, our total becomes 2.5 billion of EB-5 capital repaid from the projects. This is pretty much the industry standard now. It is something that was introduced by Can-Am way back. We create a limited partnership. You, along with other investors, are limited partners in this limited partnership. The job of this limited partnership is to lend money to the borrower for those specific activities detailed in the project document. During this time, your money remains in an escrow managed by a third-party escrow agent. The way the money is deployed is after the borrower provides the expense reports. For that money, that amount of money, the loan is deployed, and then the proof of investment comes from those expense receipts. Like I said, Can-Am is one of the oldest and the most successful regional centers, and our formula is pretty straightforward. We don't like to get creative with our investments. We look for borrowers that are well capitalized, asset classes that make sense in that geography, and don't pigeonhole ourselves into a singular kind of asset. We also look for projects that don't necessarily need EB-5 money, but it's a good cost reduction tool for them. By that, I mean that there is enough upside and skin in the game for the developer to continue with the project, even if the EB-5 funding wasn't available. And we provide this funding at an attractive rate to ensure project success. Transparency we hold very at the very core of our company philosophy. We provide regular updates on the project. We have been present in India over the last 8 to 9 years. Since then, we've enjoyed the trust of 500 plus families. A lot of them who've moved on to the conditional green card stage, and 100 of them who have completed the entire process and have been repaid. Now, this number again is an older number and doesn't include our most recent repayment. I mentioned transparency. Canam is probably the only one that gets itself third party audited by a global accounting firm. And we make this available to all the investors that are talking to us. It's available on our website, it's part of our introduction email, because we understand that it's very hard for somebody to evaluate a project or an investment partner across the world. And it is a very personal investment that you're making. Given our experience and our expertise, we've also enjoyed working with some of the biggest companies in the US, including Tishman Speyer, Fortress, which is around 50 billion asset under management company. Uh, we work with universities, we work with utility companies, and really, it's something that differentiates us and the kind of assets that we are able to structure the EB-5 investment for. These are some of the examples of our past projects. Now, a lot of people assume that EB-5 projects are real estate. While a lot of them are, we've also done a lot of infrastructure projects. We've done the first private railroad in Florida, which was then bought over by the Virgin Group, and it's now called Virgin Trains. We've done commercial office space, we've done multifamily residential, we've done oil storage terminals. Essentially, what we look for is that the asset should make sense in that particular geography, and there's a clear business case for the money to get invested there. And now I would like to pass it on to Anurag, who will talk about some of the latest updates and, of course, the gold card news that's been doing the rounds recently.
Thank you, Piyush. Good afternoon, everyone. So I'm just going to add to what Piyush said, just talk about how the current program is in summarizing the current program, the Reform and Integrity Act. What are the benefits and how is it different from the gold card? Now, the reform and integrity, according to as how the current act is, the EB-5 program is, you're looking to make an investment of $800,000 into project financing, and you're getting this principal amount back in ideally in around 4 to 5 years. In contrast, the golden card is a 5 million donation. The other difference is currently you have when clients from India, they do it for their children who are planning or already in the US. So they use the LRS limit. Obviously, Nilpa and Lloyd will cover on the taxation and other aspects. Now, in this, you're allowed to remit $250,000. So, parents, grandparents, they pool in the money for that 800,000. When it becomes 5 million, it becomes a little difficult to do it. Whatever is available in public and whatever we have heard in our discussions, as of the current act, there is a grandfathering clause of 30th September of this is you can find it in public knowledge, is 30th September of 2026. Even in case for the gold card to come in, it has to be passed by the House of Representatives as well as the Senate. So there isn't any discussion. We get a lot of queries from clients saying that, oh, there have been these applications. There's no money come in. It has to be passed by both the houses. There's also a grandfathering clause, so it's so if someone is interested for, because they have a family member who's in the US studying or working, and they want to opt for the EB-5, I think this is the best time to do it, because what we're seeing is a lot of clients are not sitting on the fence. They're making a definitive decision whether they want to do it or not. Also, the another if the gold card, there isn't any information about the gold card. Now that's another issue, because if the gold card is what it is, and it's similar, apart from that donation amount, it is similar to how the current act is. I'm not sure how much of what would incentivize a client to look at it. So if there is any tax benefits, there is some estate benefit, if there is certain benefits, then clients may look at it, because at the moment it's a sunk cost, right? Even if, and we clearly don't have any idea whether what is the time horizon. Also, in our experience globally, when people look at investment migration programs, they look at about 10% of their liquid assets for this. So 5 million, you first of all, you need to have about 50 million US dollars of in liquid assets, and then make that 10%. So globally, you're saying you're looking at around 100,000 people. So it remains to be seen how it plays. So I would whenever we discuss with clients, we always tell them that if you're sure about it, this is the best time to do it. And we still have to wait on certain information coming in for us to be able to advise you better. Now, just to add to Piyush, just from the timelines point of view, you're looking at from the route to citizenship, you're looking at, you need to have at least 5 years of permanent residency to become a citizen, and he's already explained to you about the entire process. So yeah, so that's I thought just a summary of the program and what are the discussions we're having globally. Yeah. Is it Nilpal?
Lloyd, requesting Lloyd to come in for the US tax and regulatory implications.
Thank you.
Thanks, Piyush and Anurag. I think that was quite insightful to hear about the EB-5 program construct. And Anurag, you touched upon the gold card, and you're right, absolutely. For it to make sense for the investors to pursue a gold card program, there ought to be significant both income and estate tax incentives. Otherwise, it's an expensive version of the EB-5 program without repatriation of capital. That could make it a non-starter for a lot of folks. I'll move on to some of the pre-immigration tax planning opportunities, as well as ideas. I think what is very critical for anybody who is pursuing an EB-5 program is to understand what are the tax consequences of taking up a US permanent residency. To begin with, the EB-5 provides you a green card. Yes, there is an eventual part to citizenship, but to begin with, what you will get is a green card. And one of the misnomers that I have seen in the past is people have misunderstood what does a green card mean from a tax obligation perspective. So I think that is something that is very critical for folks to understand. As a green card holder, you are on par with US tax residents, US citizens, and you will be taxed on your global income, on your worldwide income, irrespective of the fact where you actually spend time or live. So even if you take the green card and let's say you are living in India, For the entire 12 months, you will still owe US taxes and you will have obligations towards US taxes on your global income. I think this is one of the first and foremost points that most folks should realize when they are going through the EB-5 program. You will have obligations from an income tax perspective. You will have to file annual tax returns. There are disclosure obligations. You have to disclose all of your financial assets across the globe, outside the US. So you have to disclose your foreign bank accounts, your demat accounts. You also have to disclose accounts where you merely have a signature authority. So you may not have equity interest in companies, but let's say you're a director in a corporation and you have signing authority on their bank accounts. You got to disclose those accounts as well. And for all other financial investments where you have significant ownerships, it could either be a corporation or a partnership, or if you're beneficiaries of any trust, or if you're a trustee of any trust, there are additional reporting obligations. So there are several both income tax payment obligations as well as disclosure obligations that are very, very critical. Each of these forms can have standalone penalties of US $10,000 per year for non-filing. So you got to work with competent professionals to ensure you're fully compliant with your tax reporting obligations. The US has quite extensive international tax rules. There are controlled foreign corporation rules which apply to corporations where more than 50% shareholding is owned by US persons. There could be implications on the income of the companies you own. So not only the income that you derive directly, but even the income of the companies where you are a majority owner, more than 50% owner, may be subject to US taxes depending on how those companies are structured. PFIC or passive foreign investment companies are another very, very important set of rules. These apply to set of financial asset classes that are similar to mutual funds, AIFs, and these can alter your effective tax rate in the US. So while you invest in direct equities where capital gains may be taxed at a long-term rate of 20%, PFIC assets like mutual funds may be taxed at 37%, which is the peak US federal tax rate. So there's a significant delta, incremental delta in American taxes that you'll have to pay if you have investments in PFIC assets. So I think some of the key income tax concerns for Indian investors is it's important to understand what are the differences in the India and the US regime. Of course, we can't cover the entire gamut here, but couple of elements which we should be very familiar with. There are several tax breaks even under the Indian tax law. Certain incomes may be exempt. Long-term capital gains up to a certain amount is exempt. Capital gains have a reduced income tax rate now at 12.5%, whereas the US rate is 20%. So there could be differential taxes you owe. There are several regimes in India where you can reinvest your gains either by a second asset or invest in certain bonds, and therefore you are able to defer Indian capital gains tax. All of these are rules that are available under the Indian laws. So if you have obtained a green card under the EB-5 route, you will still have to pay American taxes, even though you may not owe any India taxes, or you owe reduced India taxes. So it's important to understand the incremental taxes that you will owe when you are a green card holder. And as I said earlier, mutual funds specifically is a key asset class that is usually present in most portfolios. Unfortunately, they are taxed under a very punitive regime. You either pay mark-to-market taxes on your mutual fund incomes on a regular basis, or you could pay taxes at the marginal tax rate, that is 37% plus an interest charge. So you could pay as high as 45% taxes on your mutual fund investments. These are some of the key income tax differences, that you should be aware. And there are several such other matters that are of importance. In addition to income tax, what is also very, very relevant is the US estate tax regime. US has, a gift tax regime that applies to gifts made by US tax residents. US also has an estate tax regime that applies to the estate of US tax residents, when they pass wealth to their next generation. As we speak today in 2025, the annual or the lifetime exclusion from estate taxes, the threshold is 13.99 million. What this means is for an individual who passes away in 2025, up to 13.99 million worth of assets will not be subject to estate duty. But if you have an asset net worth in excess of 13.99 million, the individual estate will owe an estate duty, and the highest estate tax duty rate is 40%. So for wealthy individuals, family businesses, and anybody who has a net worth in excess of 14 million, the estate tax is something that you have to be concerned about. And 2025 has a sunset window. This limit was increased by Trump in 2017. At the end of 2025, this number is expected to go back down to roughly about 7 million, unless the current regime extends or makes this limit permanent. So this year is a very critical year for anybody who already has a green card, or any US persons need to be looking at their estate planning. But somebody who's considering a green card application or an EB-5 application, going forward, this limit could either be 13.9 million, it could come down to 7 million, but you need to think about how you plan for estates. So parents who are sponsoring EB-5 for their children need to consider structures to plan around estate duty. Else, eventually in the future, there could be as high as 40% haircut on the assets. On gifting during the lifetime of the individuals, there are smaller limits for doing tax-free gifts. The current year limit is about $19,000. So if you make a larger gift as a US person, if you gift more than $19,000 to any other individual, you have to pay a gift tax. So either you use a portion of your lifetime exclusion of 13.9 million, or you actually make a cash payout and pay gift taxes. So gift and estate taxes are something that are very important, and this is in addition to the income tax obligations that you have. So very critical to understand these matters. I'll move on to some of the pre-immigration, tax planning ideas. And as I mentioned earlier, there are several differences between, how India taxes certain asset classes vis-a-vis the US taxes. So before the conditional green card is through, or even when you are starting the entire conversation, with folks like Piyush, etc., exploring EB-5 projects, you should consult with professionals to look at certain pre-immigration steps that you ought to take to optimize the taxes for the individuals for whom you are making an application for the green cards. I think one thing that's very important is you got to review your investment portfolio. You need to understand what are the US tax classification of the various asset classes that you hold. If you own equities, mutual funds, AIFs, private equity funds, real estates, understand how the US will classify each of those asset classes. Are any of those businesses considered to be CFCs or controlled foreign corporation? Any of those asset classes are classified as PFICs or passive foreign investment companies. Very, very important to understand the nature, because you may have an opportunity to get out of these asset classes. So before you get the green card, you could look at reviewing your entire asset portfolio and getting out of the asset classes that do not make sense from a tax perspective. Of course, you may want to hold on certain assets from an economic perspective. That is fine. But at least from a tax perspective, if you can make your portfolio more tax efficient, this is the time to do so before the conditional green card comes in. Some of the simple ideas that you could do is you could consider what we call stepping up the basis in your assets, which simply means selling the asset and then buying it back. so that you reset, your cost basis. For example, today, long-term capital gains in India is at about 12.5% plus applicable surcharges, whereas the US is at 20%. So you could look at selling some of your equities, paying a 12% tax and buying it back. Yes, there is a frictional cost, but at least you have now reset your cost basis to current levels, and therefore avoided that incremental 8 to 10% taxes that you would have incurred if you would have sold the assets after getting the green card. So stepping up a base in your assets is one option. Before you get the green card, you could look at accelerating certain income. So if there is a bonus due or there's some stock options which you're looking at exercising, there are certain things that you could do before the green card kicks in. So you should definitely look forward at least 1 2 years into your income streams. Are there any elements which you can prepone, selling certain investments, taking certain dividend distributions from your family companies, or exercising certain stock options? There could be several activities you could do to prepone certain incomes into your Indian tax year. So before you become a US taxpayer, can you take advantage of the Indian tax regimes and therefore not pay any incremental American taxes? So that's another option that you could consider. Similarly, the other side of the coin is, can you defer certain losses or expenses? So if you're sitting on certain assets which are depressed in value, the real estate or stocks, maybe you can consider selling them after you become a green card holder, so that you can take advantage, of those tax losses. US has something called the check the box regime. You can elect tax classification for the businesses that you own. So you can look at, liquidating some of your interest through check the box elections. Several options. Mainly, what you got to do is work with competent professionals to do a thorough review of what is your investment and asset portfolio, and what are the opportunities to streamline them before you become a US taxpayer. You could consider gifting out certain assets to India. In India, there are exemptions if you make gifts to certain specified relatives. So that's a significant opportunity for you to move assets to family members without incurring any gift taxes. You could also give gifts to any US relatives that you have. Of course, your US relatives may have to report those if the values are exceeding 100,000. But pre-arrival, or before you get the green card, you could consider gifting of certain assets. And last but not the least, definitely from an estate planning perspective, one must consider setting up trusts. If you have significant assets, you need to evaluate whether it makes sense to house certain assets, in trusts, depending on where the assets are. The assets are located in India. You definitely need to look at setting up Indian trusts. And can you transfer some of your assets into those trusts? Of course, the US has something called the look back rules. You may not be able to avoid entirely the income tax obligation. So if you transfer certain assets to an Indian trust and within 5 years you take up US residency, the US will look back to the assets in that trust and say, hey, you own these assets, so therefore you need to continue paying taxes on the income of those assets. But you can still structure those assets in a way so that it is not a part of your estate. So you can achieve estate tax protection. You may not be able to achieve income tax protection if it is done within the 5 year time frame, but definitely you can plan for estate tax protection. So considering the use of trust in India, and perhaps my colleague Nilpa will talk a little bit more about this in the future, but definitely trusts another vehicle that you should look at it. I'll hand it over to my colleague Nilpa to talk about some of the other India tax and regulatory implications. Thank you.
Thank you. Thanks, Lloyd. That was really insightful. Uh, now that you've learned about the EB-5 program and the US tax implications, let's learn about the India tax and regulatory considerations. So first of all, from an India perspective, if you are making an investment in EB-5 project, there are two ways in which you can do it. One way is that you use your funds which are lying outside India in your foreign bank account, but This funds should have been earned when you were non-resident in India and you were resident overseas. Those funds can be used freely, and there is no objection to use those funds how much ever. However, when it comes to India funds, and if you want to remit Indian funds overseas to the US, then obviously we need to think about the liberalized remittance scheme, which is from our Reserve Bank of India. There we have a threshold limit of US dollars 250,000 per financial year. Also, what is important is once you make remittance under the LRS scheme to a foreign bank account, the funds should be used for making investments. So till the time you invest in an EB-5 project. So till that time also you need to make sure that the funds are invested. If the funds are not invested, then those funds need to be brought back into India after 180 days. So it's very important to invest those funds. So even if you invest in certain securities and those securities you sell off those securities, make sure that again you invest in some other securities, but those funds should remain invested. One more important consideration is that the remittances under LRS are subject to TCS provisions in India, and there is a 20% TCS on the remittances exceeding INR 10 lakhs in a financial year. So therefore, the remittances have to be planned accordingly. Now, coming to the income tax considerations, like what Lloyd said, once you get the citizenship of US, you become a you're required to pay tax on your global income in the US. But the catch here is that say you get the citizenship, but you continue to live in India. India taxes the residents based on their number of days stay and not the citizenship status. So therefore, if you are a resident and an ordinary resident in India, then you will pay tax on your global income in India as well. And therefore, it may lead to a double taxation. And in case of a double taxation, you can claim a foreign tax credit. So that means that you can claim a credit of the taxes which are paid in the US against your India taxes. Likewise, I will just touch upon the US law also, that if you are paying tax in India and US on the same income, you can claim a credit in the US as well, obviously subject to its foreign tax credit rules. Now, supposing in a scenario where you live in the US, you get the citizenship and you live in the US and you just visit India for meeting your relatives and etc., or for just short-term visits, then you may become a non-resident in India. As a non-resident, you still continue to pay taxes on your Indian sourced income. Yeah, next slide, please. Now, as an Indian resident, if you are still an ordinarily resident in India, you will have to disclose your foreign assets in your India tax return. So one important thing is that if you make an investment in an EB-5 project, you have to disclose that EB-5 project also in your India tax return. And this is important because a lot of people don't do it. So you need to disclose that, and also you need to disclose your foreign bank account in Indian tax return. If you don't do that, the penalty is huge. It is huge as 10 lakhs per financial year. Therefore, the disclosure requirements are mandatory for people who continue to be ordinarily resident in India. People who become non-resident, they are not required to disclose foreign assets in the Indian return. Yeah, next slide, please. Yes. So Lloyd touched upon the trust structure. So I will just briefly talk about what a trust structure is. In a trust structure, there is a settler. Settler is somebody who is creating the trust and somebody who will transfer its cash or assets in the trust for the benefit of the beneficiaries. And the beneficiaries are usually your children or your wife, your children, your spouses, etc. There is a document in place which is called as trust deed, which will cover all the terms and conditions of the trust. Somebody needs to maintain the trust. Like we have board of directors in case of a company, we have trustees in case of a trust. And we have the concept of protector, not very widely used in India, but yes, US has this concept of protector, and it is mainly used where, you know, you have the Indian settler and you have the US beneficiaries. We use this concept a lot in the trust deeds. Yeah, next slide, please. Yeah. Now, there are four types of trust which are listed here, and these are only from India perspective. One is specific trust, a trust in which settler has determined individual share of beneficiaries. So the share of beneficiaries are known from the start, and therefore this is called as a specific trust. Discretionary trust, where the shares of the beneficiaries are not known. So you may know the beneficiaries. Okay, I have two children and those two children are beneficiaries, but you don't know how much have to be distributed, and it is at the discretion of the trustees, and that is called as a discretionary trust. Then we have a revocable trust. Revocable trust is a trust wherein settler has a flexibility to revoke the assets which are transferred to the trust. The advantage here is that the settler doesn't part away with the ownership of the assets. It can take back the assets. And trust, however, the disadvantage here is that the assets are not protected from the settler's creditors. So therefore, the ring fencing is not available. Then we have an irrevocable trust, which is the most used in India, where settler cannot gain the re-ownership of assets which are transferred to the trust. However, assets in that trust are protected from the creditors, totally ring-fenced. So these are the four types of trust which are available in India. So as I said, the most widely used is an irrevocable trust and a discretionary trust. Discretionary trust is because the shares of the beneficiaries are not known, and therefore they are protected from the beneficiaries' creditors as well. So therefore, a discretionary and an irrevocable trust is beneficial from an India perspective. However, when it comes to US, this same structure may not be beneficial from a US perspective. For example, if you set up an irrevocable trust, that is considered as a non-grantor trust in the US, and therefore an irrevocable trust may have to make annual distributions to the beneficiaries. So how do we structure it really from an India and a US perspective? How do we marry both the laws is something which is important. But that really depends on the family structure, on the citizenship and the residential status of each of the involved, like the settler, the trustees, and the beneficiaries. And then we come, arrive at a trust structure which is beneficial for everyone. So I think that's it with our presentation on the EB-5. Now we can take up some questions. We have some questions in the chat box. So we will just take up one, maybe we can take up 3, 4 of them. The first question is for Piyush. Piyush, what do you think is the key motivation for investors from India to apply for an EB-5?
I think the key motivation is essentially parents doing it for their kids, and the key motivation is to just not have the hassles of H1B, the whole lottery system. And also, once you're on an H1B, your career progression is fairly hindered, and the whole uncertainty of your status in the country and the residency in the country dependent on the employer. So just to circumvent that, and that's mainly the main use case for investors investing from India.
Sure, thank you. Thanks, Piyush. Coming to you, Lloyd, there's one question for you that what do you think, how does the classification of a trust as a grantor trust impact the taxpayer's liability for US taxes? So
Yeah.
maybe
Yeah.
what's the difference between the grantor and a non-grantor trust? That would be
Yeah,
useful.
this is a very important distinction. So the tax implications uh, on the trust income really depends upon whether the trust is classified as a grantor trust or a non-grantor trust for US tax purposes. Typically, if we set up an Indian revocable trust, it would be classified as a grantor trust. Most Indian families where, let's say, the parents are Indian citizens, Indian residents, and they are doing this only for the benefit of their children who have gone through the EB-5 program, let's say, and taken up green cards. So wherever you have a family construct where the parents are Indian citizens, Indian residents, whereas the kids are US green card holders, a grantor trust structure works well. It's a revocable trust. During the lifetime of the parents, all the income in the trust, assuming all the income is from Indian sources, is only taxed in India. It's not taxed in the US. So the US tax liabilities only start coming into play once the trust becomes non-grantor, that is upon the demise, of the parents. So this is one structure that works well. A non-grantor trust is where, in most cases, you set up an irrevocable trust. In an irrevocable trust, the tax implications are usually to the beneficiaries. I'm talking about the US tax implications. And that's why, as you mentioned, there is a need to do annual distributions, from such trusts. Else, those incomes or those trust distributions could be taxed at, significantly punitive tax rates. So the classification between grantor and non-grantor trusts are important. Irrevocable trusts can also be structured as grantor trusts, but those require significant, tweaks, and there are very specific nuances on how that needs to be done. And you need to look at it very, very carefully.
Right. Thanks, Lloyd. Lloyd, I have one more question for you in the chat box. Say if one new LPR declares himself as a dual resident and use tax treaty tiebreaker to file 1040 NR with Form 8833, reference IRS publication 519, would this be considered as abandonment of status by US CIS?
Right. It's a very interesting question, and something I come across quite regularly with our clients. Here's what at least we advise. Anybody who's going through the EB-5 especially, right, where there is a period where the green card is conditional, and there is a time frame for the conditionalities to be removed. While yes, theoretically, even in year one, owning a conditional green card, from a tax perspective, you have the option to do a TT tiebreak and file a 1040 NR, which is the non-resident tax return. But that's not something we generally advise. And if you speak to most immigration counsel, they will advise against doing it, while the conditionalities are still, applicable. So definitely, in the first few years, we don't advise to do 1040 NRs. There's no rule which says you can't do it. It's more of a practical advice. Theoretically, you can do. It is not considered to be abandonment per se. Once you become a long-term resident, and a long-term resident is defined as a person who holds a green card for at least 8 years in the last 15 years. So once you are a long-term green card holder, which means you've held the green card for more than 8 years, then yes, after you become a long-term green card holder, if you file a 1040 NR, that is considered, nothing happens to your green card per se, but it is considered to be an expatriation act from a tax perspective, and there can be tax consequences. So to answer that question, just to summarize, in the initial years, perhaps it's not advisable. You should speak to your immigration counsel and take that advice. We generally prefer not to, but we've seen cases where it is necessary and the tax implications are significant, and therefore treaty tie breaks are being considered as well.
Sure. Thanks, Lloyd. One question for you, Piyush. While you would have answered this question, probably you can again answer it. When is a good time to start evaluating EB-5? Especially in today's scenario, I know it's immediate, probably you may like to answer this better.
Yeah, so I mean, there are timelines involved. You are potentially looking at a 12 to 24-month time period of obtaining a conditional green card. I think the right time to start evaluating is especially like if you know your kid is going to study in the US, it's not a matter of if they'll face challenges with H1B. It is more like when, and it's closer to when they're graduating. So you can really ideally start planning, let's say when they're in the high school, or when they start their undergrad in the US or postgrad, like depending on what they're going to study there. But that's pretty much would be an ideal time. Of course, with concurrent filing now, a lot of people who are already on H1B and working there can apply for a change of status as they apply for I-526. But do consider about a 2 to 6 months sort of an evaluation timeline. It's more towards 2 months because you are looking at uh, the investment, and also source of funds could take 4 to 8 weeks.
So thanks, Piyush. Uh, Next question is for you, Lloyd. What US tax obligations if I sold a property in 2025 before entering US as a green card holder? And what will be the US tax obligations after getting green card if I will sell a property in 2025 before December 25?
Yeah, I think what is important is to understand whether the individual is currently already in the US or no. I think that's a very important nuance, because if the individual is already physically present in the US, even if you don't have a green card, and depending on what your visa status is, you may already be a tax resident. So to answer that, before you get the green card, question is, are you already a tax resident because of your number of days stay? If you are, then yes, you will owe capital gains tax on the sale of property. You'll get a credit for any taxes that you paid in India, but you may owe certain taxes. If you're not present in the US, let's say you are living in India, you applied for the green card, then your residency starts on the first day you set foot, with your green card, right? So there is a start date in that sense. In that scenario, anything that you've done prior to setting foot in the US would not be taxable in the US. Of course, once you get the green card, uh, any income that you earn globally is going to be taxed. So that distinction is important.
Sure, Lloyd. I think we are done with all the questions in the chat box. So thank you everyone for attending this webinar. If you still have questions, you can send it to us and we will answer them. Thank you so much. And thank you, Lloyd. Thank you, Anurag. Thank you, Piyush.
Thank you, Nilpa. Thank you, everybody.
Thank you, everyone. Thank you, Lloyd.